Good evening. I'm Harold Holzer, and I'm the Jonathan Fanton Director of Roosevelt House. And on behalf of Jennifer Rabb, the President of Hunter College, it's a pleasure to welcome all of you to this historic house and to welcome all of our viewers on C-SPAN as well to this special evening. We're very pleased to welcome David Kaplan and Bert Newborn this evening, here to talk about David's new and, would you say, timely book, The Most Dangerous Branch Inside the Supreme Court's Assault on the Constitution. So we arranged this talk back in the spring. We knew only that it would be beautifully timed and scheduled because, after all, this Monday was the first Monday in October, and the Supreme Court session, of course, began as per routine. We did not know that David would arrange other activities to occur, so that we had to turn people away from this evening. I'm even told that he had to revise his book at the very last minute, and that those of you who have written books know that the very last minute is not the routine that book publishers enjoy pursuing, but all of us are fortunate that this book is so timely in every sense of the word, and particularly fortunate that we have its author tonight. And of course, what could be a more appropriate setting than to meet in the home of Eleanor and Franklin Roosevelt? Some of you may have heard that President Roosevelt had his own problems with the court and his own reasons for thinking it was the most dangerous branch. For those of you who don't know the history of the House and are first-time visitors, with apologies to those who have heard this before, but this is a home that was the wedding present of Sarah Delano Roosevelt to her son and daughter-in-law in 1908. It was really conceived as two separate houses with one street entrance. So Sarah lived in number 47, the western house, and Franklin and Eleanor got number 49. But as soon as Sarah entered the premises and used the dining rooms upstairs, which you will see during our reception, she immediately declared that they were much too small for people in their station, and she broke through the wall. And as Eleanor wrote later, her mother-in-law was on her side of the house at the least expected moments for the next 25 years. Or as we refer to it here, the first New Deal. But it was a great real estate deal. Speaking of which, when Sarah Delano Roosevelt died, Franklin put the house on the market. It was acquired at a discount by Hunter College, which was a favorite for Eleanor. She spent a lot of time with students and at the library, for all of $50,000. That's how much this double townhouse sold for, and it's not on the market, so no ideas about. And 75 years ago, next month, Eleanor cut the ribbon outside on the street and turned the house formally over to Hunter College. And we're going to celebrate that anniversary soon, as well as Eleanor's birthday on October 11th and the 70th anniversary of the Universal Declaration of Human Rights, which she championed. So it's a very historic place and a historic time of recollection and appreciation. But back to tonight's program. David Kaplan worked at Newsweek for 20 years. His cover stories included profiles of Justices William Brennan and Clarence Thomas, not to mention George Steinbrenner, who's not on the court, but he did get a cover story, George Lucas, Mayor Giuliani, and he interviewed a majority of the Supreme Court justices for this book. I don't know if it was 5-4 cooperating or 6-3, you'll tell us. He's the author of 3 previous books: The Silicon Boys, about the culture of Silicon Valley; The Accidental President, about the 37 days following the 2000 election, which was also the basis for the HBO drama Recount. His last book was called Minds Bigger, a biography of the largest private sailing yacht in the world, which won the Gerald Loeb Award for the best business book of the year. David also practiced law on Wall Street and was a White House intern. A lot of information to unpack there. I always hesitate to use the cliche that our next guest needs no introduction, but Professor Burt Newborn really does fit into that category. But it's too much of an honor to have him here, not to dwell a bit, because all of us in New York, all of us in this country are in his debt for his brilliant legal work, his teaching, his advocacy, and his writing. He is the Norman Dorson Professor of Civil Liberties and founding legal director of the Brennan Center for Justice at NYU Law School. He has been one of the nation's foremost civil liberties lawyers for a half century, serving as National Legal Director of the ACLU, Special Counsel to the Now Legal Defense and Education Fund, a member of the city's Human Rights Commission. He's argued numerous Supreme Court cases, litigated hundreds of important constitutional cases on the constitutionality of the Vietnam War, for example. The Pentagon Papers case, he worked with Justice Ginsburg when she headed the ACLU Women's Project. Just an extraordinary record of dedication. In 2001, in recognition of his scholarship and his work in the courts, he was elected to membership in the American Academy of Arts and Sciences. And some of you may know he is also a movie star, because in 1996, Professor Newborn appeared as Jerry Falwell's lawyer in Milos Forman's The People versus Larry Flint. And I have only scratched the surface with the biography here. I will tell you that my daughter, Meg, wanted very much to be here tonight. She was an NYU law student. She took Professor Newborn's class. She served as his teaching assistant 15 years ago, but because of his influence, after wasting some time in private practice, she is now teaching legal writing at Brooklyn Law School, and she has a class this afternoon. But our family is in his debt as well for his mentoring. Anyway, thank you both for being here. Thank you, Professor Newborn, for joining David Kaplan to talk about the most dangerous branch. Our format will be familiar to those who visited before. Our speakers will converse for about 40 minutes, and they will take your questions. Please wait for the microphone when you are called on, because we're recording both in-house and for C-SPAN. And afterward, we will host a reception and mandatory book signing opportunity upstairs. So let me take this opportunity again to thank you all for coming, and to thank our speakers, and to turn it over to David Kaplan and Professor Burt Newborn.
So thank you for that all too generous introduction, not of David, but certainly of me. It'll tell you something about my teaching ability, that your daughter didn't go into practice. David was my procedure student also. He decided not to go into practice. I have peopled the United States with law students who've decided not to practice after listening.
But I'm teaching at NYU once a week, so that partly inspired.
Well, that's great. Good. I thought we'd start, because I'm not sure you guys all did the assignment. I thought we'd start by asking David just to lay out his thesis in a very short way, so that we have a kind of beginning point where we can all start from. Then I'll ask him a question, and then we'll go back and forth for a while. At about the half-hour mark, I think we'll turn it over to you, because this is really a forum, I hope, for many of you to ask us questions, and we'll try to answer them. So why don't we begin, David, with what's this all about?
So unlike in law school, where we were only called on every few weeks, I'm going to be called on over and over and over again.
Repeatedly.
The book has two ideas, or two parts. One, it's a behind-the-scenes narrative of life at the court. A look at all of the justices' personalities, quirks. It's some attempt to explain that these are, though they live in a marble temple and wear black robes, they're just human beings. They're not gods. So, for lack of a better word, there's gossip in the book. But fundamentally, number two, the book is an argument that the court has become too interventionist, too involved in American life. So the book takes on a range of cases, 5 or 6, over the past 50 years that I argue the court should not have been involved in, from Roe v. Wade on the left, a decision liberals liked, to Bush v. Gore, deciding a presidential election, Citizens United involving campaign finance regulation, Heller, gun control decision, and some others that conservatives adore that I argue the court, well, also the court shouldn't be involved in. So I like to think I'm an equal opportunity offender. I had to give that elevator speech to the justices I met with, sort of summarize what the point of the book was, and I had a liberal justice and a conservative justice each say to me, well, I half agree with your book. and that's sort of the point. They, of course, disagreed on which decisions they didn't like. And that's the argument. I think the problem with that court adventurism, interventionism, I argue, is that it delegitimizes the court. It wounds the court's prestige. It helps enfeeble Congress. There are all sorts of reasons why Congress isn't very good these days, but it doesn't help that congressmen and senators, and I talked to a bunch of them, are altogether happy to look across the street at the court, let the court do Congress's job for them. Number 3, it distorts presidential elections. In 2016, 25% of Trump voters who didn't like him, his temperament, his policies, voted for him anyway because they thought, correctly so, that he would put the right kind of nominees on the court. And 4th, I think you can argue that the court's involvement in American life helps lead to the distorting effect, the kind of confirmation circus that we're having with Brett Kavanaugh. You can blame the Brett Kavanaugh situation on him. You can blame cynical, better vetting by a president to pick a nominee. You can blame senators, but I think you can lay blame fundamentally at the court itself. It's only because the court gets involved so often that the stakes in confirmation battles have become so high. Fundamentally, on a lot of issues, the court runs the country, and now a single vote will determine key social and political policy. So the core of the book is, do you really want a country, a democracy, where the court is so important? And yet, that question about the court's role rarely gets asked. If you remember back long ago to the first round of confirmation hearings for Brett Kavanaugh 4 weeks ago, there were questions about abortion, about executive power, and so forth. Not a single question was asked along the lines of, say, Judge Kavanaugh, can you tell us an area of law or a case where you think the court did best to stay out? Nobody even thinks of asking such a question because the court's power is assumed. My book tries to question that role.
Okay, so let me lead by asking the obvious question. Surely you think it has some role. The Constitution says nothing about judicial review, not a word. Judicial review enters the Constitution, as many of you know, and as David certainly knows, through John Marshall's reasoning in Marbury versus Madison, where he argues that it is a necessary consequence of resolving a dispute is to say what the law is, and that will then have its own effect. But unlike European constitutions, unlike many constitutions around the world, our Constitution doesn't define what it is the Supreme Court is supposed to do when it engages in judicial review. In fact, it doesn't even define a Supreme Court. The only person required to exist in the Constitution is the Chief Justice. And the Constitution doesn't say how many justices.
By the way, that's something the current Chief Justice finds very pleasing.
Yes, it does.
In some respects, he would prefer there to be a court of a single jurist.
And now there may be one, or at least there was for a long time, and his name was Kennedy. But the fact is, we have to fill it in. I mean, the lines are not there for us. It's a coloring book with virtually no lines. And you make a very powerful argument that the court has exceeded its legitimate role. What I want to know from you is, what do you see its legitimate
Oh,
role?
I wouldn't argue.
And where do you find it? I mean, why is your idea of legitimate role any better than somebody else's legitimate idea of role if it isn't there in the text?
It's all interpretation. And, you know, the definition of judicial activism is what the other guy does. We're all judicial activists, and I don't have a problem with that. You'll hear the trope at confirmation hearings that I want a judge who interprets the law but doesn't make the law. All judges make law. Of course they do. They have to choose between this law and that law. They have to, in some respects, they have to make it up as they go along, and there's no problem with that. I would not argue for an impotent court at all. As I argue in the book, one of the court's greatest moments was Brown against the Board of Education, desegregating public schools in 1954. That was a great decision. I think the rights of free expression in the First Amendment, the rights of criminal suspects in the Fourth Amendment, no unreasonable search and seizures, the right to a fair trial, no cruel and unusual punishment. All of those rights need to be vindicated by some branch of government, and it should be the court, because you can't expect the popular branches, the chief executive and Congress and the state legislature, you can't expect them to protect unpopular opinions or the rights of murder suspects. If not the court, who else would do so? Who else would protect those rights? So I'm entirely in favor of an aggressive court in those areas, but that doesn't mean an aggressive court in all areas. And the court, as Louis Brandeis said 100 years ago, the most important thing we do is not doing. And when I interviewed the justices and when asked that question, you sometimes got this funny look of, well, of course we should get involved, all the more so when you see what goes over across the street in Congress, or when you look and see who's president. How you divide the cases that the court ought to get involved in and the cases the court ought not get involved in is hard. I argue the book is largely an argument on how to do that, and greater minds than mine have been having this debate for more than a century. I would point out that in addition to the court intervening when it should not, the court doesn't intervene, I argue, when it should. So in the area of partisan gerrymandering, where states are in charge of drawing their voting districts, both for state elections and for congressional districts, and the court decades ago said that you couldn't have racial gerrymandering. That would violate equal protection under the 14th Amendment. But the court has resisted for decades, saying that partisan gerrymandering, where the ins in power draw the lines to keep themselves elected and to make sure the outs can't gain power, not based on race, but based on political power. And the court this spring chose not to get involved. People thought that Justice Kennedy might be the decisive vote to get involved. He ducked the question, 5-4, the case wasn't considered. To me, that would have been arguably the most important case at the court, at the very least, since Bush v. Gore in 2000. And yet in that kind of area, the court raises its hand and says, not for us, for the time being, it's a political question. It's for the political branches to decide. What I argue is they should have done exactly the same thing in areas like gun control, interpreting the details of the Voting Rights Act of 1965, campaign finance regulation, abortion, and, though I argue it more gingerly in the book, even same-sex marriage. It is not that I disagree with the outcomes in all those cases. I disagree with many of them, but my bleeding heart liberal credentials, I think, are reasonably secure. I support extremely liberal abortion laws. I support same-sex marriage. I just think those victories ought to be achieved in legislatures and in Congress. And we're all going to see what happens when a resolutely conservative court has 5 votes. Whether it's Brett Kavanaugh or somebody else, you're going to see this court reach out and decide cases in the area of the First Amendment and the reach of federal power that will make your head spin. Liberals won't like it. Conservatives, of course, who argued for judicial restraint a generation ago, will be altogether thrilled with those rulings. And it's that hypocrisy that's at the core of my critique.
Well, let me take you up on it, on some of it. I share your, as many of you know, I share your concern about the partisan gerrymandering cases. It seems to me that the court has essentially abandoned its role as a guardian of the integrity of the democratic process by allowing partisan gerrymandering to get so out of hand. But the argument is the reason we can't get involved in partisan gerrymandering is we don't see the standards, we don't see the raw material that judges usually use. We don't see the text, we don't see a single political theory. How do we know what a fair lineup is in setting up district lines? And their argument is exactly what you say. There are some things that we shouldn't do. And the best way to decide what we shouldn't do is things that where we lack the traditional raw material for judicial analysis. And partisan gerrymandering is the very first place they look.
The difficulty of drawing lines is not alone a reason not to attempt to draw them. I mean, Roe v. Wade, for example, was line drawing.
Yeah, but you think that that was wrong.
Correct.
Well,
but I'm saying take the court on its own terms.
Oh, no,
it's happy to draw lines.
No, yeah, but you can't say, what I want to do is two things. I want to say, whatever the court does will support my position, even if what they're wrong, but I won't tell you why my position on a particular case is right and another case is wrong.
I was only making the point that sometimes you have to draw lines. Partisan gerrymandering as a principled question is easy because democracy itself, which I support, notwithstanding the current effects of democracy, but democracy itself can't solve partisan gerrymandering. You can't expect structurally the political branches which want to protect incumbency to come up with a system that's going to hurt incumbents. Now, some legislatures have acted correctly, and some have appointed independent commissions to do so, but most have not. And I much prefer the court getting involved when it is making structural changes, trying to allow democracy to flourish, than picking winners and losers in substantive policy areas like abortion or gun control or campaign finance regulation. It's hard. I don't have a grand theory in the book of how you determine that. And I had enough trouble keeping the book at this length, discussing 5 or 6 cases. But, I mean, I think Citizens United, campaign finance regulation, was a difficult case. I think there is a non-ridiculous position why money is speech and why regulating money in politics violates the rights of expression on individuals. But there's obviously a compelling alternative argument dealing with corruption and so forth. I think in a close case like that, it's an area where the court would do best to leave it up to the people, leave it up to the legislature. There are lots of other First Amendment cases where it shouldn't do so. It's the same argument, I think. There might be reasonable positions on gun control that the court considered in 2008. But if it's as the Chief Justice once said, if there's a tie, and I wouldn't acknowledge there's a tie in that case, if there's a tie, let the legislature decide. Too often this court is happy to substitute its judgment because it's convinced it's got the right answer.
Well, what about ties? Let's move this over, for example, to Dennis versus the United States.
That wasn't on the final exam.
I know. It's I made it up because I'm desperate.
This is bringing back nightmares back in law school. Professor Newborn.
This is the worst First Amendment case you can think of. This is the case that upheld the conviction of the leadership of the American Communist Party and put them in jail during the McCarthy era just because they were the leaders of the American Communist Party. They weren't alleged to have done anything other than be the leaders of the party. That case went up to the Supreme Court. There were arguments on both sides. There was a very strong national security argument, strong enough to persuade Learned Hand, strong enough to persuade people like Frankfurter, but
Learned Hand on the lower court.
on the lower
Yeah.
court, on the Second Circuit. But to me, the answer can't be that the court should have stepped back in that case, because there were powerful arguments on both sides.
Of course not. In that area, protecting the minority rights of communists, unpopular views, that's at the heart of the First Amendment. You don't need a First Amendment to protect popular views. You need a First Amendment to protect unpopular views, whether they're white supremacists, communists, Ku Klux Klan members, and so forth.
So by
That's you have to look behind the purpose of the First Amendment, and in that, Dennis cries out for First Amendment. The defendants in that case, they cry out for First Amendment protection. That case strikes me as easy. The court got it wrong.
Okay, but why isn't the same defense available to them in Citizens United, where I passionately believe the court got it wrong? I broke with the ACLU, with the organization that I spent most of my career. I broke with them over campaign finance because I thought that they were too rigid in defending the First Amendment in that context, and wanted to develop a theory in which we could uphold serious regulation of money in politics. But I acknowledge that there are really hard arguments on both sides. But at that point, it seems to me to say just because there's hard arguments on both sides, the court should throw up its hands and walk away. The answer is, do what you did in Dennis. Get it right for a change instead of getting it wrong. But don't withdraw institutionally and say, we give up on the court.
Well, I think I waffle a bit in the book, and I think that in the pantheon of terrible court decisions, campaign finance, Citizens United doesn't quite get there, because I think there are plausible First Amendment arguments. But I argue they did get it wrong. And whether I argue that the court shouldn't have taken the case or whether they should have ruled the other way is not particularly important to me.
Oh, yes, but it is important to your thesis, because what you're arguing in your thesis is there are some kinds of cases that they shouldn't get involved in at all.
Correct.
That's for the people. And I want to just counter-argument and say, you can't mean that just because there are hard arguments on both sides.
But I can arrive at the same place by saying the court takes it nominally and says we're going to leave it to the people. In this close case, where maybe speech, where money amounts to speech, but also where you've got this very strong arguments on the other side about corruption and perception of corruption in politics and the effects of advertising and so forth, the court can nominally get involved, rule on the merits, and say that's up to the legislature. It's a close case.
Okay, but
I wouldn't necessarily yield to the position. I think I provide that degree of nuance in the book where I say it's not simply that they should have walked away from the case.
Yeah,
They should-
you wouldn't have written the book if there was just Citizens United. I mean, you wouldn't have been...
Correct, but I also argue, even in the context of Roe, I think the court shouldn't have taken Roe, much as Ruth Bader Ginsburg herself argued in a speech at NYU and previously in a law review article before she was on the Supreme Court. But whether you arrive at whether you conclude that Roe shouldn't have been taken by the court in the first instance, or have them rule nominally that this isn't the time for us to get involved and this is best left to legislatures, which is a substantive ruling. It's saying there is no constitutional right to abortion. I can live with either.
Well, let's do that.
either way.
I wanted to talk to you about Roe, because Roe's the
I
case...
was afraid of that.
Yeah, Roe's the case that'll get him run out of town on a rail. So Roe...
I'm not invited to cocktail parties anymore on Martha's Vineyard.
You argue that the paradigm of the case that they shouldn't have taken was Roe. I mean, the cases they should have decided were Brown, dealing with racial segregation in public schools, Baker versus Carr, which is the one-person, one-vote case, and then the line of First Amendment cases in which that's the court doing what it should do. The court doing what it shouldn't do is deciding Roe. And
Well, I argue, I mean, if I have to pick, I don't say which of my children I love more, but I'm happy to say which Supreme Court decisions I hate more. I think Bush v. Gore was even worse than Roe v. Wade, but sure, I'm not a fan of Roe v. Wade, and I don't think it was a close case.
What mistake did they make by getting involved?
It's the classic kind of...
Did they not have judicial raw material to do it?
Well, sure, they had some, and nominally the case came to the court mandatorily. The court had to take the case because back in those days there was mandatory jurisdiction, so the court had to do something with it. But they could have either said we don't think this case is ripe for adjudication, as constitutional lawyers will use that word, or they could have said we find the most restrictive statute, perhaps, to be unconstitutional, but we're not going to, in effect, legislate a grand policy based on viability or the trimester system for all time, or perhaps they could have, there were other ways, stick with those too. And Ruth Bader Ginsburg, the Thurgood Marshall of the women's rights movement, has frequently said, too far, too fast. The court would have done better to rule narrowly.
Yes,
And I mean, my argument is based, I hope, on principle, but it's also based on looking what Roe wrought. I think it's controversial, and friends have attacked me for it, but you can argue that Roe is responsible for the radicalization of the Republican Party. You know, Rockefeller Republicans are things you read about in museums now. And you could make an argument that but for Roe, you never would have had Ronald Reagan, and you wouldn't have the level of kookdom that you have in the Republican Party now. Now, it's not a straight line, but Roe certainly helped to radicalize the party. It helped to energize a previously quiescent movement of social conservatives. Not a straight line. There are people who argue with some persuasiveness that might have happened otherwise. But I think the far better argument is that Roe did things within the political system that otherwise wouldn't have happened. And of course it did, because before Roe, both sides could fight it out.
And I couldn't say the same thing about Brown. I couldn't say that when the court finally woke up to the fact that racism was an enormous problem in American society and was not being dealt with by the political branches and forced us to take a good hard look at ourselves, that didn't precipitate a massive backlash. The Democratic Party lost the South, not because of Roe, but because of Brown and really enforcing Brown. Would you say, as a matter of tactics, that we would be better off with segregated schools and a strong Democratic Party in the South?
I wouldn't remotely argue that the main reason to object to Roe is a tactical argument. I only make the observation. I also think Roe is not Brown by any stretch, and I spent a considerable amount of time in the book, probably more than my editor here in the first row would have liked me spending on a case from yesteryear, but Brown is the classic case where the court should have gotten involved, not because necessarily the other branches weren't doing their job. If the other branches aren't doing their job, that alone isn't a reason for the court to intervene. But the language, the text, you mentioned text before. I don't dismiss the importance of text. The text of the 14th Amendment is so clear as to prohibit segregation in schools and housing, and et cetera, that makes Brown pretty straightforward, notwithstanding that, yes, 58 years earlier, they got it wrong.
For more than 50 years, they thought that it required separate but equal. As long as it was equal, separate didn't violate the 14th.
And of course, Marshall proved it wasn't, but Plessy was wrong, as the court said it in Brown. Plessy was wrong on the day it came out in 1896.
Let me flip your argument on Ruth Ginsburg's argument. She did argue that Roe, it was a tactical mistake because the court jumped too soon and there was political momentum being built up. But a very difficult question was asked of her shortly thereafter. How long would you want to wait? How many women were supposed to be dead in back alleys trying to get an abortion? How many lives would be destroyed before you would give the signal and say it's now time for the court to come in? The idea that what the court does is balance this before it comes in, I think is a terrible idea because it introduces an utterly unprincipled political component to what we should be striving to make a more principled decision-making.
But the court always has to decide which. The court's docket now is entirely discretionary. It has to decide which cases to take. You want to argue that realpolitik ought to have no role?
No, in deciding what they take, fine, but you're arguing two things. You're arguing one, something I agree with, which is the court should be highly conscious of the political consequences of what it does. And therefore, if a case shouldn't be decided because the country isn't ready for it, you deny review. Because it takes 4 votes to come up. But they didn't have that luxury in Roe, as you admit. They had to decide Roe. And Roe was...
Well, no, they had to take it, but it's easy enough to dismiss these cases very quickly on non-substantive grounds.
Well, but then what you mean is that they're manipulating doctrine to get rid of cases that they're supposed to have. I can't think of a better way to ruin the institution than to have the institution operate in a way that simply manipulates doctrine to decide when they decide cases and when they don't.
I think they would say, legitimately, where there's wiggle room, that will be one of our factors.
that's fair.
Manipulation of doctrine is
Well, that's fair.
strong.
Let me use Ruth's argument against you on this one. She said that tactically they jumped too soon, and that difficult question was asked of her. She did say, though, that the result in Roe was correct. She did not say that courts should not decide the issue. She said they should have decided it as an equality issue, the way they decided Brown, because you cannot have a system in which women will be equal. No social system has ever had equality for women unless women can control their reproductive processes. Otherwise, they are inevitably unequal. They're pulled out of the game over and over again while we're scoring points.
I acknowledge in the book that the equal protection argument, which was not Roe, and which RBG has embraced, would have been a better route to a decision. And I acknowledge that maybe it would have been the right decision. I have enough trouble, as we're seeing, dealing with the cases that I dealt with on their own terms without hypothesizing alternative ways to the argument. My hunch is that I still think the argument that abortion is fundamentally a political question, a policy question, best left to the Democratic branch. My guess is that probably would have won out. But might I have won out? I mean, I have an open mind. I'm too old to be a justice, but I'm happy to tell President Biden I'm available. Or President Harris, pick your favorite. But Ginsburg's argument, and I don't know that. Well, I don't know how she would have voted in Roe if she was on the court in 1973. I did ask some of the justices, how would you have voted in 1973? And it was interesting because, they're all talking to me on background. I can't say who I talked to, and I can't quote them directly. That's fine. But when I asked that question, they would say like an Animal House. Well, that's double riveted off the record, and you have to turn off your tape recorder. Because I typically tape interviews just because it's easier than writing notes, and then it's harder to make stuff up. Just kidding. But when I would ask that question, most of them would duck it, but several of them would say, I don't think I would have voted with a majority in Roe, and that was interesting to me. I don't think I'm talking out of school to tell you, no, that wasn't an admission I had to get from, Justice Thomas, or, well, I'll leave it there. So I think there is much acknowledgement that Roe, as written, was a really bad decision. And the Academy went to town, as you know, on Roe, including a lot of liberal professors.
But the Academy went to town on Brown. I mean, if you take
a lot less so.
Oh, the criticism of Brown was absolutely brutal.
Not as across the board. I mean, I went back and lived with this stuff. Herbert Wexler at
Columbia.
Sure, but I think it was more muted. And my book, The Most Dangerous Branch, is in part a response to a book called The Least Dangerous Branch, written by a famous law professor at Yale named Alexander Bickel, who died in the 1970s. And his book, written in 1962, was an attempt on his part to work out support for Brown against the board. It troubled him doctrinally. The result obviously pleased him. If you're looking for a companion piece, a companion book to these 350 pages, that's a pretty good one. But I think you're quite right. that liberals objected to the decision, but I don't think in nearly the degree or to the extent to which they've criticized Roe.
All right. Well, let's.
Many of
end-
them have been voted out of cocktail parties as a result of Roe back then.
We should remember, by the way, when Roe was decided, it was not seen as a hard case. It was a 7-2 case, and it did not engender immediate.
It took a
response.
while for political resentment to build.
it
The
was-
other thing that's interesting about Roe, you sort of forget this stuff until you go back and relive it. It wasn't fundamentally a decision about the rights of women. It was fundamentally a decision about the rights of doctors. There was still a paternalistic aspect. But go back, whatever you think about the outcome in Roe, go and read the decision. It's terrible. There are a lot of other awful decisions. Read Bush v. Gore. But there are decisions that I don't agree with that are well written. Roe reads like it was delivered from the well of the Senate. And that isn't constitutional law.
So let's before we turn it over to you guys, I'm going to say I want to ask you a couple of things on the gay rights cases because that is
More trouble.
more trouble for you.
No easy questions about Bush v. Gore.
Well, the Bush v. Gore is if there's time we can deal with it. But the gay rights cases I think are important because by the way, the fact that I'm asking these questions is a sense of how much I respect the book. It's a terrific book, and you make a terrific case in there that people have to think about. But
So I will pass the course.
no. You still owe me a paper.
Okay.
But
I'm over the page limit.
I want to push you because the gay rights cases are to me quintessential equality cases as well. However you characterize your opinions, and you root your defense of the court, and it's a wonderful defense of the court, in defending discrete and insular minorities who lack the political power to defend themselves. And if they're going to be at the mercy of the majority, that's where you say the court should come down and protect those discrete and insular minorities, race being the paradigm, and I guess you would say political folks with controversial political views as well.
Correct, as well as the outs.
Right. But what about gays? Aren't gays in exactly, maybe not today, because the world has changed so much from the time I grew up, when it would have been inconceivable to think of achieving majority support for a pro-gay setting.
I said the campaign finance decision was a close case. I think Obergefell, the decision in 2015 that created a constitutional right to same-sex marriage, I argue that case was close as well. I also say that I think it was correctly decided. But I also argue that, on balance, it probably should not have been decided when it was decided. The court would have done better to put it off, as it had been doing for a bunch of years, put it off, let the political system and the lower courts continue to wrestle with the case, and then perhaps sometime down the road constitutionalize this right. The problem, and I think it would have been a great moment for the court, as it would have been in Bush v. Gore, to say, there's some things that are not for us to do. That kind of humility doesn't exist on the court. They're virtually all arrogant, and proudly so. They wouldn't use that word. I argue that I have no problem with the gay rights decisions leading up to Obergefell. I think the decisions on sodomy, Defense of Marriage Act, I think those were correct. But I think the question of same-sex marriage, for reasons that some of the more persuasive dissents, particularly from the Chief Justice, from John Roberts, militate discretionarily in the court staying out. And the argument that this is a discrete and insular minority, I don't think holds water in 2015. In 2015, when the court decided gays and lesbians were winning victories throughout the country, and it's true that in terms of percentage, the percentage of gays and lesbians in the country is small, their political power was unquestioned. To argue, though, that they are still a discrete and insular minority akin to African Americans in the country, I don't think is convincing. Now, there were other arguments to rule that way. I think the case was probably correctly decided. But I think I would quote RBG in saying too far, too fast.
Right. In reading the book, and you should, please read the book, you should distinguish 2 points that David is making, because one point I think is a point that I agree with and is not really contested, but another one he leads to that I do disagree with him passionately about. He argues that, and Obergefell's a perfect case, because in Obergefell you argue, what you really don't like about the case was its timing.
Correct.
You think they jumped too soon, and that if they'd waited, either there would have been such an irresistible political force built up that we could have solved it through the democratic
Irresistible
process.
and judicial and lower courts, perhaps.
Yeah. That's a very different argument from saying that it was illegitimate for them to get involved at all. And you in the book, I think, elide those 2 points, because you can say, yes, this is not the time, wait a while. But that's not what the critics of the court are saying. They're saying they shouldn't get involved at all. There is no role for them in certain.
God forbid that I try to include some nuance in the book. I mean, it's not journalism I was doing. In 1,000 or 5,000 word, that's harder. But sure, I think I do try to straddle that fence. And if I get an A- on the book as a result, I can live with that. But I think my argument, I would acknowledge that my argument on same-sex marriage and Obergefell is different than the argument I make, perhaps, on some of the other cases. I wouldn't argue that that many of the other cases are ill-timed. I would argue they just were not matters for Supreme Court involvement.
Let me pin one last question. Do you say the same thing about Roe? Because Ruth Ginsburg's argument is too soon, but eventually she would say it was time to come down.
Maybe. Let's see what the briefs look like. I like to think that even after working on the book for a year and a half, that I have an open mind. If the equal protection argument wants to be made, and the court sort of talked about it in Casey, the 1992 ruling upholding Roe but cutting back on the constitutional right. I'm happy to consider the possibility, but my instinct is that the equal protection argument probably wouldn't win over. It's pretty hard, I think, to make an equality argument on the rights of women in that case. I'm open to it. And I've read what Ginsburg has argued about it. My guess is I wouldn't be persuaded. I don't have to deal with that part. I just have to deal with Roe as written on a matter of privacy or what they call substantive due process.
You just disqualified yourself. President Biden has just called me and he said,
you barely can be past your bar mitzvah to be considered for the Supreme Court, so I'm already too old. They're starting to look at people, right after the ceremony to see who they can put on the court.
So we've had our statutory exchange, and now it's time to hear from you. I would encourage. It's such an important topic, and I would encourage you to ask of either of us any questions you want, and we'll try to answer. I've been given the impossible task of calling on people. So, given my nearsightedness, let me start at the back while I can still see. Yeah.
Wait for the microphone.
Oh, I'm sorry. I was also told to wait for the microphone. Okay.
To what degree could or should the court send potential cases back to state level, either legislative or state court?
It depends on the case. There's some areas where if they don't get involved, the lower court opinion stands. If they throw out the ruling, then obviously the lower court opinion doesn't stand. Whether it goes back to the state legislature or to Congress depends on the particulars of the case. Because if the lower court said that we're going to let stand the statute that was passed, then the matter's over. But remember, in that case, the legislature can still continue to wrestle with the issue. At a real politic level, which Bert didn't necessarily want to talk about that much. The problem with Roe is once the court declared abortion a constitutional right, the legislative issue was pretty much over. The loser in that battle, the pro-life movement as it came to be called, could no longer go to state legislatures or Congress other than to tinker around the edges. That's one of the practical problems of Roe, because when something's a political dispute, both sides can rest assured that tomorrow's another day. You'll win tomorrow. So that venting of steam is what prevents, perhaps, the issue becoming overheated. The trouble when a court declares the debate over, it helps lead to what we saw with the Republican Party. I mean, Roe is the worst thing that could ever have happened to the Democratic Party. That's not necessarily an argument why it was incorrectly decided, but Roe is the worst thing. And many people have argued that the best thing that can happen to the Democratic Party is Roe being reversed. That's not a reason to reverse it, but I don't think that's a particularly bad argument. By the way, I don't think that a court with Brett Kavanaugh on it will reverse Roe. I think a court with Kavanaugh and the rest of the conservatives will cut back on Roe, but will not explicitly reverse it. And I think Chief Justice Roberts, who nominally now passes for the middle of the court, will resist throwing the court into that maelstrom. And my guess would be, notwithstanding his unpleasant testimony, I think Brett Kavanaugh would veer more toward that institutional position than some of the real movement conservatives on the court, like Gorsuch and Thomas and Alito. I'm not defending Brett Kavanaugh. I'm just saying I don't think he's quite as far over to the right as some of the other justices.
Jerry Nadler?
Thank you. I'm certainly open to political arguments, but I am troubled by the notion that the court should disregard someone's constitutional right. Someone should, in effect, maintain an injury for political reasons, no matter how good the political reasons may be.
I mean, I guess I have a two-part answer. One, saying there's a constitutional injury begs the question. Until we decide there's a constitutional injury, there may not be a constitutional injury. But the court, and I think it's pretty uncontroversial, says, correctly so, that it's not in business to right individual wrongs. They only take 70 or 80 cases. A generation ago, they only took 150. They've got to pick and choose, given their docket, they have to pick and choose which cases will have the most impact, where there are disputes, splits in the lower court. So the notion that there may be some injuries that the court lets go, even though they might decide, based on an initial look, there's an injury, I don't have a big problem with that.
You know, you just mentioned, when I graduated from law school in 1964, the court decided 221 cases. In the height of the Warren years, 221 cases that were really revolutionizing aspects of American life and finally bringing equality into the Constitution. Now they're down to 77. I think if I had the ability to write the last chapter of your book, I would figure out a way to get them down to 0. I think that's the right amount of cases.
Well, you know, some people are beginning to argue that you should have an even number of justices.
I have
in fact, to
argued.
require a supermajority. So if you had an 8-member court, you'd take 5-3. If you had a 10-member court, it would make it a lot harder for them to rule it all. But I would add, Congressman, that one of the problems with talking about the constitutional rights of individuals, organizations, is with the conservatives at the helm, you're going to see further weaponization of the First Amendment. There are going to be all kinds of grievances. We heard about the alleged grievances, alleged legitimate grievances of unions in the spring, where a unanimous decision on 40 years ago was thrown out by the court. Campaign finance is, one could argue, weaponization of the First Amendment. And what about the alleged constitutional rights of business owners who were hurt by the Clean Water Act and the Clean Air Act? All these environmental rules are violating our constitutional rights. Well, you know what? With 5 votes, as Justice Brennan used to say, you can do anything. They're about to have their 5 votes. I'm not sure that your interest in constitutional rights will be quite as great if the conservatives are in control for 25 years. So my argument is that better off that maybe we ought to be less in the business of finding those rights. You know, it's interesting. There's a recent movement of conservatives, some libertarians, but mostly conservatives, called judicial engagement. You will hear more about it. There are a few pages in the book. Former conservatives and some libertarians who didn't want the court involved now can't wait for the court to get involved. We don't want restraint. The court should be engaged in protecting constitutional rights. What's the difference? George Will is a leading proponent of this. Not a constitutional scholar, though he would claim to be. I don't think he went to NYU Law School. But what's the difference between judicial engagement now and judicial restraint of 20 years ago? I know. We have 5 votes.
But that's the way it's always been. I mean, this is not the first time. The Supreme Court, before the New Deal, struck down so many important economic regulation aspects under the theory of they called it substantive due process, and they just plucked it out of the air, and minimum wage and maximum hours, so that Roosevelt, who we're sitting in his house, Roosevelt tried to pack the court in 1937. He put through a complicated system that would have appointed 6 additional justices, 1 for every justice over 70. And he would have packed the court, and they would have been a reversal. Now, what happened is the court, staring down the barrel of that, backed off and began to change its opinions. But the idea that somehow today, for the first time, we have a political court, whereas in years past we had a principled court, is you don't make that argument, and it can't be true.
That era of the court in the 1930s and a couple of decades before, I spent a lot of time in the book. Again, more than my editor would have preferred. But that era, called the Lochner era, was terrible. And that was court adventurism of the worst kind. Interestingly, you hear some conservative theorists and public interest organizations arguing to go back to some of those Lochner cases and to start ruling more in favor of economic rights. It's not individual rights necessarily that are as important, but economic rights should be more important. Second point, court packing. I would not be surprised to see that come back in the news if the Democrats take control of the White House in 2020 and the House and the Senate. In 2021, they can pack the court. It doesn't take a constitutional amendment the way it takes to change to impose term limits on the court, for example. But to change the number of justices on the court only requires an act of Congress, a bill signed by the president. And you already hear some Democrats and academics talking about that. I think it is conceivable that the level of anger and the degree of partisanship could make court packing a real issue in a way that when FDR proposed it in 1937, it was dead on arrival. There was bipartisan objection. It was politicizing of the court. It wouldn't surprise me at all if the Democrats, who are really bad, though, at politics, I argue, in this area, they bring knives to gunfights started by the Republicans. I think you might see that gain traction. Now, is that a good idea? Maybe in the short run it is. Appoint 2 justices, Merrick Garland and his golf partner, so that you get to an 11-member court and you're back in control. The Democrats are in control of the court. But then what happens if a Republican's elected something? You want to go to 13 justices? I mean, at a certain point, you're going to need a bigger building. I think the hope for the court is that kind of episode, or perhaps some of the discussion that you're hearing now, or perhaps more readers from my book, is you'll see some institutional pullback from the court. I think the best hope for the court, such as he is, and I don't have much hope, is the Chief Justice. The Chief Justice is a conservative. He is not a moderate. Don't confuse him for being a moderate. But just as he demonstrated in the first Obamacare ruling in 2012, that he was able to put aside his own policy views, or even perhaps constitutional views, to defend the court, to protect the court institutionally. I think it is possible you would see some effort on the part of this chief to try to rein the court in and see it be further drawn into the maelstrom. Is it likely? No, but I think it's possible.
I agree with so much of what you said, but here's the
Finally.
Here's the thing that bothers me, and that I don't know the answer to, and I'm not sure that anybody does. I can make and agree with your powerful attack on the court during the Lochner era. Striking down all those things was terrible. It's what Brandeis hated. It's what Frankfurter hated, that the court was out of control. I even have some sympathy for, and I will have some sympathy for the current court, arguing that they're going to go much too far. The gun case troubles me tremendously, and some of the campaign finance stuff. But those are two bookends to an extraordinary time in American life when the court got it right. And when they literally pulled us into a better place. The court spoke with a prophetic voice, starting with Warren, and they pulled us as a nation into a better place than we had been, and a better place than we would have gotten to through our democratic process. So if I want to defend the Warren Court and defend the remarkable achievements of the Warren Court, how do I do it if I take the two bookend areas where the court was, I think, getting it wrong, and say that was illegitimate, but the Warren Court was legitimate? If the two bookends are wrong, so was the Warren Court.
But that almost sounds like a utilitarian argument that I like the Warren Court, and I argue in favor of many Warren Court decisions, including the early reproductive rights cases on contraception. But your argument just sounded like, I like what the Warren Court did because they reached a better outcome than the democratic processes would have. Is that a principled argument?
No, it's not a principled argument. What it is a defense of why you need an institution like the Supreme Court to be able to come, or the federal courts generally, to be able to defend people who are doomed to lose in the political process. Without a strong Supreme Court that reaches down and protects women, because when you say that gays have all these rights, let me tell you something. Travel in Mississippi and say that. Travel in Texas and say that. Travel in places in Utah or Montana. The fact is, you can't take a national poll and say, oh, all of a sudden, because gays can work on Wall Street, and all of a sudden now we've changed our thinking of gays, that they don't need this protection anymore, or that women don't need this protection
I wouldn't
anymore.
disagree with that at all. The problem is the victories that you ultimately achieve in the political system, which can take a long time, and things are not good these days in the political system at the federal level and at many state levels. But the victories that you do achieve politically in the democratic branches, you could argue, are more enduring
Well, that's-
and more principled than what you get in the court. And do
but
you
how
really
long-
do you want the vortex of political discussion and agitation and presidential elections turning on how do we staff the court? That was a key issue in 2016. And much of what you're going to hear from Trump and his lieutenants leading up to the midterms is going to be, we have to hold the Supreme Court. Look what we've done with the federal judiciary. And the polling just out about the effect of the Kavanaugh controversy has been that it is emboldening and energizing conservatives. That strikes me as problematic. I understand why it is, because that's where you win.
But the price you exact is the loss of this the capacity of the institution to protect the weak in many settings. Because what you do is you say, okay, the weak is suffering, and we have this institution that could protect them, but look at all the bad things that will happen if the institution acts.
I don't think that those protected or vindicated in the gun control ruling, or Shelby County, the ruling about the Voting Rights Act, which did anything but help African Americans, or in campaign finance, or in Bush v. Gore, necessarily were looking out for the interests of the poor and the weak.
No,
I don't argue in the book at all that those rights shouldn't be looked after by the court. I don't argue for an impotent court. I just think there ought to be more judgment applied.
You just think they should vote differently.
No, hardly. Again, I think they voted correctly in Roe and Obergefell, but I don't think that. I think we would have been better off for the court and as a society if those matters would have continued to be debated in the political branches.
Okay, let's go back to the.
I'm at least able to separate out my view on the outcome and the process.
Right over here on the aisle. Yeah.
First of all, thank you for a wonderful discussion. Philosophic question. Do you think in the next 20 years it's possible that the court would be less a political body and more of a jurisprudent one?
We'd
Is
have
there
to get
any
into
way
what,
that can happen?
No, I am not hopeful for the court. I think the self-aggrandizement of the court will only grow. I think they're going to take this car out for a ride. Clarence Thomas has been arguing to do so for 30 years. Justice Gorsuch and Justice Alito aren't far behind. They're sitting in the back seat. Roberts is more reluctant. Kavanaugh, or whoever winds up taking that seat, I'm not sure. But they're close. I mean, and depending on whether Ginsburg lasts 2 more years or 6 more years, if they get enough votes, then Roberts is no longer, then the Chief Justice is no longer in the middle. So no, if I understand what you mean by that terminology, no, I'm entirely pessimistic.
Do you see any traction for the idea of throwing out Roe v. Wade? Because number one, abortion only involves women. Men don't need them. So why not just have women decide it? And number two, separation of church and state. Conservatives believe and others believe in the sanctity of human life, but if you don't believe in abortion, don't have one. So maybe we could throw out Roe v. Wade and redo it.
I don't think Roe will be thrown out, and I don't think Roe should be thrown out. I think precedent is important, and if I were a justice, I'd be, I think, circumspect in overruling many decisions. So I don't argue in the book that Roe ought to be overturned.
Yeah, Dorothy.
Hi. I just want to throw out a couple of thoughts. One is, even Ruth Bader Ginsburg, who I, like probably most people in the room, I vastly admire, can sometimes be wrong, number one. Number two is, I think we should more thoroughly think about what her message was about Roe v. Wade and about her approach to equal protection issues. And one reason she was wrong about the analysis of Roe, Bert pointed out, too far, too fast. Do people in this room know, for the next 2 confirmations of Supreme Court justices, how many questions were asked about Roe v. Wade? 0. That's how uncontroversial that decision was. Ruth Ginsburg, a large focus of her thoughts on this has been about, and throughout her career, including when she was doing her women's rights equal protection litigation in the 70s, it was about not getting too far in front, of the American people, because it is risks. Here it was not that.
I'm sensitive to there being a lot of questions. Is there a question?
Take 1 more minute, but I don't want to, we have a lot of folks that want to ask questions.
I would just appreciate it if you would address sort of a more complete, a fuller view of what she was getting at, and in getting at in also, I think, on gay rights and same-sex marriage, where basically the court followed her advice, which is they didn't do a national ruling the first time out. Isn't that right? They waited till a large number of states had acted.
I agree. On same-sex marriage, they were more incremental, largely led by RBG, and I think that was correct. I'm not sure how to address the rest of your question other than by saying, read those 30 or 40 pages of Roe. I mean, I understand it's a controversial issue. I understand their strong views. I wrestled with how to address it correctly, and really trying to emphasize that I think there is a difference between one's political views, and mine are clear on abortion, and what the court's proper institutional role is. I'm not sure.
I'm going to go to this side. I was swinging too far to the right.
What is the, excuse me, what is the first thing that comes to your mind when you hear lifetime appointments and, I say this, behind the palm of my hand, lying under oath in a Senate confirmation hearing?
Well, the first thing that I think of with lifetime appointments is academic tenure. And I don't want to hear any argument about that. I like academic tenure.
The first thing I think of on lifetime tenure is a lifetime appointment is great gig. I mean, I would get rid when our founders set up lifetime tenure in the late 18th century. Life expectancy was a lot different. I think everybody pretty much agrees, other than the current justices and would-be justices, which is to say all law professors, including, what at last count was 2,000 of them signing on to oppose Brett Kavanaugh. I think a single-term 18-year appointment would be a great idea for all kinds of reasons. Eventually, once it kicked in, you would stagger when justices were named. Every president would get to name one every 2 years, and people who were 60 years old would be considered. You wouldn't just be looking for 45 and 50-year-old nominees. As far as the whole Kavanaugh thing about lying under oath, we do not have the rest of the evening. But I mean, I have sat next to Brett Kavanaugh at rubber chicken dinners, and we're not going to get into necessarily what I think of Brett Kavanaugh, but I was appalled by many parts of his testimony. Now, I understand that he had an audience of one to satisfy in the last round of testimony. He had to please the president, who might have pulled his nomination if that testimony didn't go. But Kavanaugh is suffering a price, and even if he sits on the Supreme Court, I think he will pay a greater price than Clarence Thomas has paid in 30 years. Thomas has not paid much of a price, and he certainly hasn't paid it within the institution. Within the institution, apart from being beloved by court staff and others in the building, because I had asked about Thomas, most of the justices will all say, we serve here together for decades. We put that stuff aside. He's an equal member of the court, and we all get along. And I believed it, even though that there might have been a thought balloon going on in the rest of the answer that, well, yeah, I remember that unpleasantness from 1991, sure. Microphone.
Hi, thank you very much. Very interesting. You were commenting how Obergefell might have been a little early, and I was just wondering, would you agree that Kennedy was necessary for Obergefell, and now that Kennedy's gone and likely replaced by Kavanaugh, that the window for Obergefell turned out to be very, very small indeed, and that there was really only 1 or 2 years there where Kennedy was on the court, and that it could have been heard. And so based on what you were saying, where maybe it was a little too early, would you agree that if it had not happened then, it probably wouldn't have happened for a generation or so until Kavanaugh kind of character was gone? And is that a good thing?
I mean, life is timing, relief pitching is timing, and so is constitutional law. I mean, right? Obviously, if a different justice was in Kennedy's seat, it might have gone the other way, sure. And the victory that gays and lesbians achieved might not have been achieved for 5 or 25 years, absolutely. Justice Kennedy, who reviewers say doesn't do particularly well in the book, was an important justice. He was an important justice because he was the smartest or the most thoughtful. He happened to have the seat in the middle in much the way that O'Connor was the most important justice of her generation, and earlier and before her, Justice Powell. And nobody's asked who I think on the court most behaves in the way that I prefer. I think it would be Stephen Breyer. Now, he's considered one of the liberals, but I think Breyer, to a certain extent, Kagan, to a certain extent, Roberts, exhibits some of the traits that I would hope for. Breyer, in fact, among them, has voted to uphold more acts of Congress than any of the others. I did hear that Elena Kagan out at a law school in California recently told the students that in a tie court, a 4-4 court, she would expect, she didn't say hope as it was reported to me, but that she would expect more minimalism, more gradualism, more restraint, in much the way the court behaved in the spring of 2016, and then later 2016 into 2017, where the court only had 8 justices
Yeah, well, that's why
after
people.
Scalia died.
Yeah, that's why people are actually seriously talking about the value of an even number court. Madison, if Madison would jump down here, Madison would say, you want to force them to compromise. You want an institutional mechanism that will force them to compromise.
But the idea that the party in power, remember, Trump says we have to hold the Supreme Court as if it's just another, as if it's a super legislature. The idea that the party in power, the one that blocked Garland, the one that is now ramrodding Kavanaugh through to confirmation, the idea that that party would ever agree to disarm and endorse is nonsense. And I think, because I think, both sides are hypocrites. I think if, just say, Hillary Clinton was president and you reverse the chess players, the Democrats would never agree. We haven't had control of the Supreme Court since the Warren Court. By God, we're going to take this puppy out for a ride.
Yeah, just as a historical matter, since the Civil War, Republicans have controlled the Supreme Court from 1865 to 1937 and from 1972 until the present. There's been one burst of Democratic control of the Supreme Court from 1937 to 1972, and that's all you have to hear. You know that that's the Warren Court.
And I would agree with that description, but my quibble is that we think about the court that way. And now you've got a court with Kennedy off of it, where on hot-button issues, not boring stuff involving ERISA or taxes or, God forbid, admiralty, you can pretty much predict how they're all going to vote. If you can predict ahead of time how the justices are going to rule, what do you have the court for? I mean, then it really is just a super legislature.
No, I think, well, this we really could stay here all night, but it is conceivable that it's much more deeply principled than that, because in the hot-button cases that you're talking about, what you usually have is 2 values in play. Forget the text, forget the history, forget all the things the judges say they do when they're doing it. The case presents values of equality and autonomy. And those 2 values are always in balance. Letting somebody do what they want, or doing something in order to make sure people are equal. And when you can get both, as you do in a lot of free speech cases, those are easy cases where autonomy and equality point in the same direction. You have easy cases. The hard cases is where they're in conflict, and you have to choose whether you want autonomy or equality, affirmative action, hate speech, campaign finance.
But don't you get the sense that with, for example, David Souter, who left the court 10 years ago, or with Justice Powell, or Justice Harlan during the late 50s and 60s, didn't you get the impression that you could see the wheels turning in trying to reconcile that difference
Those two
and to apply neutral principles
Sure.
or non-political principles in choosing? Do you get that sense now?
Yeah.
You do now still?
I do. I actually think I do not think that you have 9 people up there who say, what's the partisan way to decide this? What's the way that will advance this? They're trying. They are trying to do the right thing.
I would completely agree that they don't explicitly say we're going to vote as we would as a legislature, that we're
And they would pass,
partisans.
and they would pass a lie detector test for that. They don't want to do that. So, but what happens is when you have 2 arguments that are closely balanced, as you pointed out, something's got to break the tie. And what breaks the tie is that Republicans go down the line for autonomy, and Democrats go down the line for equality. And if you want to take a look at how the court is going to break, in a case in which autonomy and equality are in tension, then you tell me which party controls the court. I will tell you what that precedent is. And I don't know that there's anything wrong with that. I don't know if there's another better way to resolve it.
We will have to do part 2.
Okay.
I think that's a kinder view of what goes on, but I would acknowledge that they're not explicitly partisan.
am I getting the cut? One more, right over here.
We'll be here all week.
Yeah. I'll give you David's home phone.
Thank you.
I want to thank you too, because until this evening, I never knew just how brilliant the founding fathers were to have left the Constitution blank on what the Supreme Court would do, and the fact that there's no prescription as to what cases will be accepted and what will not. What I'd like to know, though, well, I assume, of course, that the founding fathers knew that you two would take over eventually and bring that up. But
If only more people believe that.
what I would like to know, if you had the opportunity to write into the Constitution provisions that would help to resolve the problems you've been discussing, would you be able to do that? And are there other democracies which, in their constitutions, have codification in their constitutions which would prescribe what cases will not be taken and which cases will be taken?
What a great question. Can I enroll you? Would you come down to the law school? We talk about that. The answer is, I think I could write something. But that's only because I have an ego the size of Chicago. But I think I could. And what I would try to do, I bet you David and I could sit in a room and we would come up, if not with a constitutional provision, criteria that we would agree on. And the criteria we would both agree on is that if you show me somebody who's doomed to lose in the political process, for whom democracy is simply a tragic series of losses, and I'll show you a candidate for protection in the Supreme Court, that the Supreme Court should be protecting that person. And that's why I disagree with so much of what they've done recently. We've turned out to be a Supreme Court that protects the strong against the weak, when it should be a Supreme Court that protects the weak against the strong. And I think we could do that. The European constitutions don't do a particularly good job of it. They're not any better than we are at.
I think we could perhaps end on a note of agreement. I would buy into that, but I think the fundamental problem we have is one of interpretation and personnel, not in the document itself. The document's done pretty good for 250 years, but I do think that it only goes so far as to argue that the main purpose of the court is structural. It's to protect the have-nots, the weak. The problem is sometimes those who don't win in the legislature don't deserve to win. Their ideas are bad. They're dangerous. They're wrong. For example, most of the platform of the Republican Party in 2016. And just because you lose, just because you repeatedly lose, doesn't necessarily mean you deserve judicial protection.
So I'm going to, if I may, before I close and thank our speakers, just mention how proud we are to have Judge Pierre Laval here, and also our advisory board member, Dorothy Samuels. We're glad to have you here. And a man who asked one question tonight. I have a feeling that if the congressional majority changes, he may be asking more questions, is Congressman Jerry Madden. This has been an extraordinary night, and we thank Professor Bert Newborn. I don't know how my daughter got through those classes, but that is a rigorous exercise you put us through. And David Kaplan, we're all going to be eager to read your book. You are provocative, brilliant, and a great guest, and we thank you both for coming tonight.
Thank you.
Thank you, Donald. Thank you.
Thank you.